I'm joined by political law attorney at Sandler Reef, Joe Birkenstock. Joe, as we are seeing the prospect of an insider trading or market manipulation scandal kind of surging into the national spotlight here, and this comes as the result of a high volume of shares being traded just minutes before Donald Trump actually made his announcement pausing these 90-day tariffs. I'm curious what the financial disclosure requirements for federal officials, whether it's somebody in the executive branch or folks in Congress, what they actually are.
Sure, sure. Great question, Brian. So there was a law passed a little over 10 years ago called the Stock Act, right, that some people are familiar with. That actually stands for the Stop Trading on Congressional Knowledge Act, which was passed as a result of a similar scandal about a decade ago about public officials making money on the information that they have because of their nature, their job as a public official. So the Stock Act effectively adds to some disclosure requirements that were passed in the 70s, so that now there is both a periodic transaction report that gets filed roughly on a monthly basis, and then also still the annual reports that are filed by federal public officials to disclose a more full picture of what they own and how they trade. So the way the transactions show up on these two reports is interesting, and I think there's going to be some information to be learned in course of comparing these reports over time.
Joe, are we going to be able to find out what day, what minute these stocks were actually traded at?
Great question. Ironically, yes, we will know what day. No, we will not know what time. These two versions of the reports that I described, the periodic transaction report doesn't even necessarily cover all of the instruments that might have been relevant here, right? You don't have to disclose, for example, transactions in ETFs on a periodic transaction report, even though they do show up on the annual report. The annual report will show the day in which somebody might have traded in a particular security, but it doesn't show what time. So we won't know whether it was right before or right after an event like the announcement on the tariffs.
And so when you're in a situation like this where, you have the prospect of an insider trading scandal, isn't the whole ballgame here knowing whether they traded before an announcement was made or after? And so how do these investigations usually pan out? Do you have to go to the SEC, for example?
Generally, yes, it's the SEC that really drives, and their approach utilizes a lot of documents, obviously, that aren't public. Specifically, the trade confirmations themselves, when you buy or sell a security, the broker will send a trade confirmation that shows to the second exactly when that transaction took place. What that obviously can't show, though, is why did you make that trade? It'll show what you bought, sold, and when, and for what price. But the hard part around insider trading for public officials in particular is you have to know why. You have to know what was the basis on which they might have made that decision. And for a lot of reasons, one being the speech and debate clause, another being the co-equal nature of the branches, it's actually pretty difficult to do investigations through the executive branch of information that might have gotten developed within the legislative branch. It's an ongoing problem in this field, really, for quite a long time.
So, in a situation where we actually do see insider trading investigations take place, where is it that they take place, knowing full well that the only way to actually prosecute this kind of thing is to be able to see those documents where we know minute by minute when these trades took place?
Yeah, yeah. So for members of Congress and for staff, senior staff and above that are required to file these reports, the real enforcement of these requirements is done by the respective ethics committees, the Senate Ethics Committee or the House Ethics Committee. That will take time, and the details of those investigations aren't necessarily public. But that's kind of the least bad option, I think, that resolves from this question of the difficulty around doing a criminal investigation by an executive agency of people that work in the legislative branch.
But even if Congress, for example, first of all, even if Republicans didn't control the ethics committee, which effectively means there is no ethics in the ethics committee, even if Congress did investigate this kind of thing, they have no enforcement authority, and so it would still be up to the SEC to enforce this, the FBI to investigate, or the DOJ to actually prosecute. Is that correct?
It is correct in terms of criminal exposure, the assessment of a civil penalty, right? All the other exposure that you have as a matter of the securities laws themselves. The ethics committees have authority over people that are in the body. So you can get fired, you can lose your job, to some extent lose your career. That's
Or
rare. It takes a lot.
in the case of today's Republican Party, just get promoted up to attorney general or something, like you get a cabinet position out of this.
Sure. So, I mean, just one counterpoint, though, right? I mean, the ethics committees are unique in Congress in that they really are bipartisan. There are equal numbers of Republicans and Democrats on each committee, regardless of who holds the majority in the body. And a lot of people point back to the Matt Gaetz matter as one that, despite his role in the Republican Party, despite a lot of reasons Republicans might have had strategically to want to keep him in that seat. Ultimately, that investigation did result in his departure from the House after years and in a very private way, right? I'm not suggesting that that means it's a really satisfying result, but there's more than zero exposure to members of the House or the Senate as a matter of those ethics processes. On the executive branch side, in a criminal sense, I completely agree. You need a U.S. attorney that's willing to prosecute. You need a Securities and Exchange Commission that's willing to investigate. And I certainly remain to be convinced that that's going to be done on a really even-handed basis going forward.
With that said, can you talk generally? I know that putting you on the spot, you might not know the exact statute, but can you talk about statute of limitations? Because I think that you and I would both agree that it's very unlikely that a Republican would be prosecuted for engaging in a potential market manipulation or insider trading scandal that would be effectuated by the very guy who is in charge of the DOJ and the FBI and the SEC, who gave all of those people who lead those agencies their very jobs. But
Sure.
but what is the general statute of limitations for this stuff, knowing that, okay, you might not have exposure in this administration, but you may in the next?
Yeah, sure. So let me make 2 points. One, the narrow answer to your question, as a matter of civil penalties, there's a 5-year statute of limitation, which is interesting, right? Because by definition, 5 years from the day that Trump pulled the tariffs down is after the end
Right.
of this Trump administration. Broader point, though, and again, I think a even more troubling one, in the perfectly captioned case of Trump versus United States, the Supreme Court came back and said that Trump himself is immune from prosecution under these activities and that his pardon power is plenary. It has no limitations whatsoever. So anybody in the executive branch and really conceivably anybody in the legislative branch who fears that they might be facing some exposure here could have that exposure wiped away in an unreviewable way by, as you say, the man who began all this initially by using social media to communicate public policy decisions.
Okay, well, now that we have effectively wiped out almost all hope, I do have one final avenue to venture down here, and that is, what about enforcement action at the states? Because these people aren't under the jurisdiction of the federal government. They're not guided by what Donald Trump by any edicts that Donald Trump says down. And B, pardon power wouldn't apply to crimes that were committed at the state level.
Yeah, all correct. I mean, it is complicated. It's not to say that it's easy to enforce this kind of stuff through a state avenue. There are state statutes against fraud. There are state causes of action that a state attorney general could investigate. They will ultimately get into zones around preemption of federal law, right? Under the Supremacy Clause, federal law is the supreme law of the land.
Right.
But there's a long body of law that recognizes states still have a lot of latitude to enforce their own laws, as long as it's not directly conflicting with the outcome under federal law.
And are there statutes that are different enough that they couldn't be that the federal government couldn't come in and basically Bigfoot the states by saying, no, supremacy clause applies, we're going to prosecute this, or not prosecute this?
Yeah, in one word, yes. I mean, again, this question of preemption obviously is one that exists across the entirety of the policy zone, right? It's not limited to securities enforcement or anything else. And there is a long body of law that explains, and it states in particular. I mean, I do have some firsthand experience with preemption of the Federal Election Campaign Act, for example. States that enforce their own campaign finance laws typically do not acknowledge preemption of federal law until the Supreme Court issues a final mandate after literally every avenue of appeal has been exhausted. So it doesn't lend itself to a narrow yes or no answer. But in terms of, can they investigate? Do they have the authority to even start looking under some of these rocks? The answer is definitely yes.
Even if the supremacy clause applied, do the states still have the power to investigate this kind of stuff and be able to actually uncover some of the criminal activity that was committed? So let's say, for example, the states did investigate, it did turn out that certain lawmakers, for example, engaged in insider trading by virtue of, okay, they bought in 7 minutes before the announcement was actually made. And even in an instance where the federal government comes in and says that the supremacy clause is going to apply, and so we're going to take over, and of course we're not going to prosecute, we're going to move to dismiss. Would that be something that the states could still reveal, where they have information, where they have evidence that they could still reveal? So even in a moment of overt corruption, at least the American people would know whether or not certain officials did engage in criminal activity.
Yeah, typically a criminal investigation, even when it's done by a state, is going to be done in a confidential way. And that's to respect the rights not only of the people who are going to be accused and potentially indicted, but to respect the rights of witnesses, right, counterparties, other people that might be involved in that circumstance. Um, in terms of a process to investigate, I would not expect a state investigation like that to result directly in public information unless and until somebody is indicted. And that's the point at which they're obliged to start sharing their information in court.
Is there a moment though where if we know, like, I understand that this is all a little bit unprecedented, but in a moment where it becomes clear that prosecution won't actually take place, then is there anything stopping prosecutors or investigators from releasing findings? So at least, if there's no justice in the criminal justice system, at least there's some justice in the court of public opinion.
Yeah, I mean, it's interesting how you point out that it's unprecedented because that's correct. And I think it's one of the many ways in which actually Trump's brazen approach on a lot of these issues is resulting in a need to evaluate questions of first instance that are that fundamental, right? Like presidents don't instruct the Department of Justice who to investigate.
Well, they
Donald
they,
Trump
they,
did
they
that
used to
yesterday,
not.
right? Exactly. Yesterday, he said, these are specific individuals that
Right.
I'm instructing the Department of Justice to investigate. So again, I'm not a defense lawyer, but if that were to take place and the Department of Justice starts sending out FBI agents and here's grand jury subpoenas, typically there's what's called the presumption of regularity, right? We're not going to revisit the decisions the FBI uses about how it goes about a particular investigation because it's entitled to a presumption of regularity. Well, if you're throwing out all the norms and the basis for that presumption in the first place, I think it might be inevitable that the courts start throwing out the presumption as well. So the same thing again with like the tradition or in a lot of ways the requirements, right? I'm more familiar with the federal rules about criminal procedure, for example, right? A federal grand jury is covered by Rule 6E, which prevents that grand jury from sharing any information it develops unless it returns an indictment. It doesn't apply to witnesses. It doesn't apply to the defendants theoretically, which could, announce that they're being investigated. But it may be among those many things that we start seeing some issues of first impression being resolved because we have a president and a Justice Department and executive agencies and everything else that are kind of going where no one has gone before.
Well, I will look to those folks to start speaking out, and certainly to the states to step in where the federal government is obviously going to do nothing. Far from investigating or prosecuting these crimes, are the ones possibly engaging in it themselves. So, Joe, I appreciate your time and all the knowledge.
My pleasure. Thanks, Brian.